Ghana for Mubekai Eye Capital Bank CEO anasa founder ayefeni William Ato Essien Mokai say enche bia che say ninsem nyina ko edija ewo court sisi amena okasa no court granting 10 million Ghana cedis bail che say ye twen ni edi na asem ewo appeals court odofo sisi no breaking news abeto on say court granting eye William Ato Essien Kaneno Capital Bank founder Ubekai no and see a court granting 10 million Ghana cedis bail see an enche ye kwa kodi na asem no appeals court odofo breaking news kese na beto dwa so begini nyina bro e wo Ghanatube for man ko na yan kwaje sansem wo nyina nchemu e wo Ghanatube no magisia.
I was starting with some breaking news from the courts because the Court of Appeal has granted founder of defunct Capital Bank, William Ato Essien, a 10 million cedis bail pending appeal of his sentence. A 10 million cedis bail comes with two sureties. He is to report to the registrar once a month and deposit his passport at the court's registry as well. Lord Eduasare is our court correspondent this afternoon. Let's get to him right now for a bit more details. Lord, what more do we know? What arguments do we know as well were put before the Court of Appeal before this bill was granted?
Right, Marina. So the substantial issue raised by lawyers for William Ato Essien was that since his incarceration, his health has deteriorated substantially, and so his continuous incarceration would possibly lead to the worst of it, and that's what they're trying to prevent. They indicated that, among other things, his continuous incarceration raises questions about the Court Act 35 that has to do with compensation by persons that have been convicted after they got into the plea bargaining with the state. They indicated that William Ato Essien, prior to his conviction, had made substantial repayment as the agreement of the plea bargaining. So his continuous incarceration was going to mess things up. Now, the state attorneys or the prosecution disagreed. They indicated that, well, he had ample time to make all those payments, but he recanted it. He actually failed to do that, and that was the reason why the High Court gave him the conviction, and then he was eventually jailed. Marina, this is the second time that William Ato Essien was actually attempting to get a bail. Now, in May, earlier this year, May 16 to be precise, he filed a bail application at the High Court pending his appeal. Now, we know that since his incarceration, he filed an appeal, and this had been ongoing. Now, because of his deteriorating health as posed by his lawyers, they indicated that they wanted him to be granted bail so that he can be coming to court and then continue with his appeal. But then the High Court refused that bail application in May, and so they sent that application again to the Court of Appeal, and this was the outcome. Now, in their decision, the 3-member panel of justices indicated that questions about the Court Act 35 had to be answered because it raises more issues about what happens when someone who has gone into the plea bargaining with the state makes substantial payments and then he's still convicted or jailed. And so they indicated that part of this will have to be taken to the Supreme Court for more interpretation. And in all this, after they said that, and then they granted him the bail of 10 million, the details of which you have indicated, Marina. And so we still be monitoring how things will play out, because you remember that somewhere last month, or early this month, I should say, several actors have been trying to put the case out there that William Ato Essien's health is deteriorating, and so there's a need for him to be put out there. We've even had the former Attorney General, Dr. Badami, just yesterday or a few days ago, indicating that he had to be released or freed because of his ailing conditions. And so this is where we are at Marina on this case.
Right then, Lord, thank you very much. Lord Edwasare in court for us with the details. But we're returning into the studio. Joseph Akable is joining me with a bit more on the man William Ato Essien and how we've got here with respect to his case in particular. Joseph, thank you very much for joining us. Let's start off with the conversation of William Ato Essien.
Order for one kasa uti semna ekosuna osha eye William Ato Essien a Capital Bank na egunu the founder and as a CEO no order for osha obekwa ko de jail afebo ana ji na me no kase ne yesi ne condition enye kra bibi a odane di enye na still an egusu di na asem wo court ti si an yase ama 10 million Ghana cedis bill yet na asem ne ko appeals court na utie nsem na ekoso na yesi the way anyama si kono de den case no was say sanso ko PM Supreme Court order for when how far William Ato Essien Capital Bank na egu no CEO no na se founder no ekwan ye de ne fa so court no yesi anya na asem ebekwa ko PM Supreme Court sisi an yesi ne health condition di enye kra bibi odane di enye crowd of four when they breaking news abeto dwa me so bi ni nyina brew Ghanatube for mama yenko na yenko to ansem ne so emra disi Ghanatube so
founder of Capital Bank, but walk us to who he is and why this big news of bail being granted him will certainly go up in the trends.
I mean, it goes up in the trends because it's very unusual. In fact, the issue of bail pending appeal is one that the courts barely grant it. The only times the courts will grant it is when there are exceptional circumstances. And an example of exceptional circumstance would be situations where, for instance, the person has been handed a jail term. If you remember the Flōw one, it's the term that has been given the person. By the time the appeal will be heard and determined, there's a possibility that you would have served the sentence already. So that is such instance that the court looks at. So it's very rare that the courts grant it, and mostly the courts lean towards not granting it. The court could also consider the likelihood of the appeal being successful, and that would also influence the court's decision. The Ato Essien situation has to be put in the context of the fact that he was charged, he was undergoing trial, he reached an agreement with the state. So he was charged alongside others for their role in the collapse of the bank. He was the founder of Capital Bank. He was standing trial alongside the managing director, a businessman, and other individuals who were participating in that particular trial. In fact, he entered into an agreement with the state to refund 90 million cedis to the state. Now, this is important because this agreement was entered into just when the court was about to deliver its judgment. In fact,
in respect of the charges
against him. It is interesting to note that on the day of judgment, actually, all the other persons who were charged alongside him were found not guilty. So no one knows what would have been a judgment of the court. But the fact of the matter is that he reached an agreement with the state which held the court's hand in relation to the judgment with him. That agreement was done under Section 35 of the Courts Act, the old law, which is still in force now. That is the law under which that transaction was done. The agreement was that he was to refund 90 million cedis to the state. The initial installment was to be paid by December of 2022, and he paid 30 million cedis as the initial installment. Now it was left with 60 million cedis. Now this is what happened. The 60 million cedis was to be paid in 3 installments. Each month there was a periodic about 2-3 months basis. He pays 20 million. After 2-3 months he pays 20 million. So there were dates that were fixed, and the court required that all those clear timelines be put in a document and sent to the court under Section 35 of the Courts Act. That was done and filed in court. He missed the very first timeline when he was supposed to pay the 20 million cedis. Then the state pushed for the sentence to be imposed, because under the law, if you miss the terms of the agreement, an application can be made for the sentence to be imposed. And so the court now imposed a 15-year sentence on him in October of 2023. So he'll be 2 years in October coming this year in terms of the period that he's been in custody so far. So just a little over a year spent in custody so far. He has already refunded 30 million cedis out of the 90 million cedis that he was supposed to refund to the state. And the latest that we are bringing to our viewers is that he's been granted bail by the Court of Appeal.
Let's do a bit more education on this particular matter. So the state pushed for the sentence to be imposed, which meant that what? He was no longer going to need to refund the 60 million cedis. Is that it?
Yes. So, I mean, once you enter into that agreement under Section 35, the law is that you are going to agree to refund the money. So you are refunding the money. Basically, you're accepting guilt to refund the money, then in default of refunding the money, the jail term can be imposed. And so once he breached the term, in fact, his lawyers had opposed the application for the sentence to be imposed. They had made the point that he was having some business challenges and that he was trying to sell some assets belonging to various companies, and that's what was proving difficult. And so he needed more time. But the Attorney General's office had said that, well, the law allows them to apply and push for the sentence to be imposed when there is a default, and with the terms of the payments clearly laid out, there's been a breach. So the application was made. Deputy Attorney General at the time, Alfred Tēars, was the one who moved that application in court, and the court granted it. Justice Cheba, then sitting as an additional High Court judge, upheld it and imposed the 15-year sentence on.
So now he's pushing for an appeal of that sentencing. A bit more education. What happens if the court grants that appeal? Means he returns to having to fulfill this financial obligation to the state?
It means that his lawyers are raising concerns about the sentence that has been imposed, and you heard Lord make reference to it. It means that what they are challenging is the 15-year sentence that has been imposed, not necessarily the conviction, because the conviction was on the basis of his own admission of guilt in order to enter into the agreement. And so the potential outcomes could be that the Court of Appeal could affirm the sentence to say that, well, the 15 years is fine. They could decide that, well, it is too harsh or excessive and bring down the 15-year sentence. Alternatively, the Court of Appeal could come to the conclusion that the 15 years is too less and actually impose a higher sentence. An appeal is a rehearing. The court has the opportunity to rehear the entire facts that were argued and the main substantive matter, and can come to any other conclusion that it wants to.
Right, Joseph, thank you very much. That's my colleague Joseph Akable with details there for us of the very latest from that case involving William Ato Essien, who's been granted 10 million cedis bail by the Court of Appeal. Is expected to go along with two sureties. He's to deposit his passport at the court's registry, and we've been walking you through the facts behind where it is that we've gotten to. He's been unwell for quite a while. There's been a lot of conversation, particularly following the AG's nolle prosequi involving Dr. Dufo. Many others have asked the question, what happens to him and all other persons who are standing trial for bank collapses in that banking sector cleanup? I'm sure the conversations will come up a lot later, and trust that we will lead it for you here on TV3. But right now, let's do a bit more stories.
Other four, when you breaking news about to dry, see William Ato Essien, defunct Capital Bank CEO and as a founder, no, or no energy and court, appeals court, a money 10 million Ghana cedis bail. Almost say there, send a mercy corner the NASM no on be pejad ya Supreme Court. Now, Mamma him say and Chabian your man 15 years a year judgment, your man 15 years on quarter prison. And I say jail, the man 15 years on quarter jail. And you see, and you say I can reach 2 years. No more in the condition of woman the yen crime to the four. The mercy corner the Osha Attorney General or Beman and Nolle prosequi. Not yes or non so, what discontinue the case now, said the other four way. And I asked him, say, Bear, Ghana phone now, as Attorney General say, to me, a man, almost in the health condition be other than the and your crowd of four. When they breaking news, I be to James beginning in our bro, Ghana to the former if you say, mobile, I can almost subscribe and no share no my notification, but on some mind, send a bear. I bring you a BB dropping content, say, I woo, when you're in pan, watch you with them, or for aha, and I made in 7 in ABC or Ghanatube so. Macramina, Madame Minas.